Hi, good afternoon, viewers. This is Adil Farooq, and you are watching Legal Launch with Adil Farooq. I'm here with new tips and new information from the legal point of view. Today, I am planning to start a series of legal things, and if you remember, I already talked generally about the real estate, about the wills, about the family law, and about the corporate law. But from now on, I am doing some small sequence of small tips relating to different topics. So to start with, I plan to start with the real estate process, and today I will cover the agreement of purchase and sale, which is the starting point and key of any real estate transaction. So whatever I talk about here, it will be general information for the public. If you have any specific legal questions, I will suggest to reach out to your lawyer or legal representative or your realtor, and they will be happy to assist you. If you want, you can always contact with us, and we will also happy to assist you relating to your any question about the real estate matters. But today's topic is only touching with the agreement of purchase and sale, and do not take this conversation as a legal advice. This is just for information purposes, because every client, every person has their own circumstances, and they should contact with their professionals, legal professionals or real estate professionals, to have to discuss with their specific concerns. Okay, to start with, what is an agreement of purchase and sale? Whenever you start thinking to buy a house or sell a house, usually a client retain a real estate agent. So this is between you and your realtor to discuss the terms of the real estate agreement, the agreement of purchase and sale, for to buy or to sell the house. And I will just give you some tips that what you should know and how to approach different aspects of this agreement. And I believe my real estate colleagues, they will always try their best to give you the best agreement which is in your interest and which protects your interest. But this again, sometimes the clients approach us to give us the copy of their agreement for purchase and sale before they sign. They need our legal input, and we always happy to assist them. But it doesn't mean that we are replacing the expertise of our realtor. The realtors have their own expertise, they have their own knowledge to apply it, because to sign this agreement of purchase and sale. And again, you do not have any, I would say, compulsion to review it with your lawyer. But if you want to, you have the right to do that. So to start with the I'll start with the purchase part. When you visit any properties with your realtor and you find out the property is right for your needs, the price, you will negotiate with them. Then you have to, the real estate agent always presents you an agreement of purchase and sale. So in that aspect, when they give you the agreement could be for a detached house, for a semi-detached house, for a condo, for a townhouse, or a condo townhouse. So all those kind of properties can be bought through the agreement of purchase and sale, and every property have a specific type of agreement of purchase and sale. And of course, your realtor is the best person who will bring to your attention that about that agreement, and that person will tell you about the agreement, about the right agreement of purchase and sale. So once you have that agreement, there are a couple of things you should verify. Even though your realtor is doing that, make sure that the spellings of your name are correct as a buyer. And if you are buying this property together with someone, maybe with your spouse, your children, your friends, or anyone else, make sure their names are correct as per their IDs. Because if there's a spelling mistake or the name is not correct, then we, being a lawyer, face some problems to satisfy to the lender about that name change or same name things, and it will increase our legal work. So this is the first thing. And the second thing is to see if the address of the property is correct. That address, of course, when you see the property, you will see what's the address of the property, and that address should be there. Don't worry about the legal description, because you don't know about the legal description. That's your realtor's job to find out what is the legal description of the house, and they will be responsible to insert that legal description in the house. Over here, I will just distinguish agreements between the house and the condo or townhouse condos. In the townhouse condos, if you are buying a unit with a locker and with a parking spot, that's again you should be concerned to find out, or you should be very vigilant to find out that your realtor has inserted the right locker number, right parking number in that first page of the agreement. Again, that's your realtor's responsibility to figure it out, that what is the legal description of that locker and parking spot if you are buying this with a house. Sometimes in few condos, even if the numbers are not there, but you have the right of exclusive use. But even if you have an exclusive use, their number of the parking spot and the locker should be in the agreement of purchase and sale. It will be helpful you to identify your locker number or your parking spot where you want to park. So once you attach those things, then it comes to the purchase price. Of course, I will not comment on the purchase price. That's totally between you and your realtor and the market of the property. That was the market of the property. So you will agree with whatever the purchase price. It should be there. And the other part is the deposit. That's also very important, that if you, let's say if you're buying a house for $1 million and you're putting a $50,000 deposit, in the deposit section they should mention that what will be the deposit of the house. If you have the if you have resources to pay 50,000, but for some reason they give you a deposit, they put a deposit of $100,000 and you didn't notice that, then you are in trouble. Because you don't have that deposit, then they have to go back and forth to fix that problem, and maybe you lose that property if the other party refuse to change the terms of the deposit. Because if you don't pay the full deposit, whatever is agreed, it means you have not fulfilled the initial terms of the agreement. So once you will do that, after that the next thing is also very important, that the date of closing. So date of closing means that is the date when you will get the house, and when you get the possession of the house. And if you have any specific date in your mind, please make sure that you have that date, whatever you have in your mind, that this is my date of closing. It may be 1st of June, 2nd of June, July, August, whatever date you want, and that date should be there. One thing, just make sure, but sometimes we saw that few of our realtor friends, they didn't notice, or for some other reasons they forget that it's a specific date, it's a long weekend, and this Monday or Friday is a local holiday, and they insert that date, holiday date, as a date of closing, which is not possible. If that is the case, then again we being a lawyer has to put some extra effort to change the date of closing. We have to, so whenever you put a date of closing, please make sure that this is a working day in Ontario, because we are talking about the properties in Ontario. So the next thing is also about the one other date, that date called the requisition date or title search date. That date is nothing to do with you, but this is important for us. Being your lawyer, we have to check the property legally, that this property is have no major legal issues. If there are major legal issues, by that date we have to notify to the other lawyer that they have to fix those legal issues before we buy the property. And usually that date, I will recommend that there's at least 10 days before the date of closing. Even if it's a shorter date, we always deal with that. But if you give us 1 week or 10 days, and if we find out some legal problems, so we should give the other party reasonable notice, so they will have enough time to fix that problem before they give the property to us. Over here, I will also I will again go back to the agreement for the condo corporation. If you are buying a condo corporation or townhouse with have a condo fee, over here there should be a fee which you guys going to pay monthly to the condo corporation, and that fee is mentioned there at that time, because always refer back to their listing, that what condo fee they mentioned. If they mentioned the condo fee $300, that condo fee in the agreement should be $300, and if they are paying more than that, that should be there. Because we saw some examples that when they signed the agreement, they said, okay, we are paying $300, the previous owner is paying $300, but at the time of closing, or actually at the time of reviewing the status certificate, we notice that this is not 300, this is 400 or even more. Then at that time you had the opportunity to renegotiate your price with the seller, or if you want to live with that condo fee, you can accept that and you proceed that. But it's important for you to understand that there will be a condo fee. Sometimes there's some misunderstanding between the client and the other, with the buyer and seller, or realtor, or buyer realtor, or seller realtor, because sometimes the realtors forget to inform the buyers that what includes in the condo fee. If the condo fee includes the water, the hydro, the gas, the cable, maintenance of the common expenses, or sometimes it only includes the common maintenance of the common expenses and insurance. And you should understand that you should also ask those questions to your realtor, that they should verify with the seller or with the condominium corporation that what includes in the condo fee. So you should you should calculate your budget, that if this is in your budget, then you can work on it, and if for some reason that's going out of your budget, so you should reconsider your position, that if you like to buy this property or not. So after looking on those things, then you will keep, then other terms of the agreement are very standard term, which you do not have any much control of those items until or unless you are buying a house under the power sale or some other legal issues in the property. So once there are some, whenever you buy a property, I will suggest that you should have some conditions. Until unless you satisfied your conditions before that, you should have those conditions. The first normal condition is the approval of your mortgage. If you have already a mortgage in place approved, you can waive that condition. If you do not have the mortgage in place at the time of signing the agreement, take a reasonable time, maybe 1 week, 2 week, 3 week, whatever is agreed between both the parties, and that agreement should be conditional on the mortgage approval. The second condition may be about the inspection of the house, because it's also important. If you're buying a resale house, there are possibilities that there are some major or minor defects on the house which can only be found by a certified home inspector. So if you have any home inspection clause, so you will have the opportunity to hire a professional home inspector. That home inspector will visit the house with you, and he will search each and every part of the property and notify you if there are any major issues. If there are major issues or small issues even, you should make an amendment in the agreement and force the seller to fix those items. Here is one problem I will tell you. Whenever you do that kind of amendment in the agreement to ask the seller to fix some certain items, I will suggest always put some kind of holdback amount, that if the seller failed to fix all those blah blah blah, whatever the different defects of the house, the buyer lawyer will be allowed to hold back a certain amount of money. You guys have to know the certain amount. You should write down the certain amount, because if for some reason the seller failed to complete those things, and then at the time of closing, we being your lawyer have to fight with the seller to allow us to hold something, but 99% the sellers lawyer don't allow us to hold any single dollar, because they say, oh, there's nothing in the agreement, and they keep claiming that they have fixed blah blah everything, they fix everything, but the buyer saying no, it's not fixed. So if you have some holdback clause in the agreement, that make everyone's life easy to fix those problems, and then sellers usually have a pressure to fix those problems. Otherwise they know that their money will be held back, and they will be forced to fix those problems even if they want it, or if they don't want it. So this is one of the suggestion. And besides that, if there's any other condition you like, for example, if you are buying a condominium corporation house or condominium or townhouse, there should be a clause to review of a status certificate, and that status certificate usually comes back to the lawyers, and we review the status certificate on behalf of the purchaser, and we notify them if there are any defect in the properties, and if there are any any special assessment is coming. We also confirm that whatever the condo fee, they confirm if this is the right condo fee or the wrong condo fee, or what is the amount of the reserve funds. So more the reserve funds, more this condo is financially stable. But this is not always the case, because if you are buying a condominium corporation which is only a 1 or 2 or couple of years old, their reserve funds will be less, and that's normal because they just born, and it will take some time to accumulate the reserve fund. If you're buying a property 20 or 30 years old, then there should be a good number of reserve fund depending on the size of the building. I always suggest my clients that in order to understand the financial situation of the condominium corporation, they should take that budget and condo documents, financial documents to their accountant to understand and take their input on those things. This status certificate also tells us as if there any court case against the corporation, if there is if that you have whatever you're buying, if you are buying a parking, or you are buying a locker, is this included in the house purchase price? Are you buying this, or use exclusive possession of the of those units? So that will also will be verified by the condominium status certificate. So, and there are other terms. If you have something special thing in your mind, of course you can always talk to your realtor, and your realtor should draft a clause according to that. And sometimes a few of my realtor friends or business colleagues, they always refer back to me if the client instructed them, okay, we need this special clause. Then we always help them to draft those clause, and they insert the clause in the agreement. That always help us to complete this transaction smoothly without having any legal problems. Sometimes another if you are buying or selling the house at the same times, remember that I know many of our clients choose that they will buy and sell the house on the same time. If you are doing that, always remember that you are putting your purchase on risk. That because if you are selling the house and the money is coming from your sale and going towards your purchase, so remember, we cannot complete your purchase until we receive your sale money, and that sale money will come only after we sell the house. And in that scenario, you will be homeless for a couple of hours because you sold the house, but your house to buy the house is in process, and we as a lawyers always need some time, few hours to complete the process, and then you will get the keys of the house. But if some reason your sale could not close on time, and the buyer of your house will keep delaying sending us some money, and they send us the money very end of the day when the banks are closed, by 6 o'clock, then most of the banks are closed, then we receive the money, but we unable to send the money to the other lawyer, and then unfortunately you are homeless, maybe for a night, or if it's a weekend, for the whole weekend, and you will have no right to claim any damages from anyone. So whenever you're buying or selling a house on the same day, keep this risk in your mind. I believe that session is very informative especially for the first time home buyers, and for a few of my clients and new buyers, and maybe also helpful for my realtor friends. If you have any question, don't forget to contact with us, and we will always happy to assist you. Don't forget to follow us, like us, and comment on our videos. And if you have something in your mind which you want us to bring into your knowledge from the legal perspective, I will be happy to bring that session online during next week. Please keep a note that we will be doing a next session on next Tuesday at 1 p.m. So until that, thank you very much. Take care of yourself, and see you next week same time, and have a wonderful week. Bye bye.